Welcome to our conversation on the ICJ's preliminary ruling regarding genocide and the war on Hamas, with our special guests, Justice Professor Elyakim Rubinstein and Judge Abraham D. Sofer. My name is Elena Maizel, and I am the Executive Director of the Israel Law and Liberty Forum. I'd like to thank all of you for joining us here today, as well as those friends and partners who helped us share this event widely, and to offer special thanks to Boris Feldman, who suggested this excellent pairing of distinguished scholars. This event is also co-sponsored by the Tikva Legal Fellowship, and I'll say a quick word about both organizations before we turn to the discussion. The Forum is a national Israeli educational initiative founded to foster thoughtful debate and discussion on Israeli law and governance, including through student chapters, founded at top law faculties, through an online journal, and through public events. Since the onset of the war, we have focused many of our efforts on the law of armed conflict, on international law, and on Israel's just war of self-defense. The Tikva Legal Fellowship invests in cultivating American Jewish public interest legal leaders, hosting an annual seminar each year composed of dozens of top law students, with additional events at law schools throughout the year. We will explain a bit more in a follow-up email after the event, so you can stay posted on future opportunities. But now, we are honored to host two legal scholars, former justices, and former diplomats to help us analyze what may be a particularly significant development on the legal front in the war, a preliminary relief ruling rendered by the International Court of Justice in a case alleging the commission of genocide in the war against Hamas. Together, we're going to analyze the case, Israel's broader relationship to international institutions, and the question of how legal and political considerations figure into international law. Without further ado, let's introduce our guests. Justice Professor Elyakim Rubinstein is the former Deputy President of the Supreme Court of Israel, where he served as a justice from 2004 to 2017. He was previously the Attorney General of Israel from 1997 to 2004, and prior to that, a district judge. His career has been dedicated to law and diplomacy, including serving as a diplomat in peace talks with Egypt, with Jordan, serving as Deputy Chief of Mission of the Embassy of Israel in Washington, D.C., and participating in the Israeli delegation to the Madrid Peace Conference. As Attorney General in 1998, Professor Rubinstein also headed the Israeli delegation to the Rome Conference, at which the International Criminal Court was established, which Israel opposed. Judge Abraham D. Sofer is the George P. Shultz Distinguished Scholar and Senior Fellow Emeritus at the Hoover Institution. Sofer's prolific work, including several scholarly books, focuses on the power over war within the U.S. government and on issues relating to international law, terrorism, diplomacy, and national security. From 1985 to 1990, he served as legal advisor to the U.S. Department of State, where he resolved several interstate matters, including the dispute between Egypt and Israel over Taba, and the claim against Iraq for its attack on the USS Stark. Sofer served as a U.S. district judge in the Southern District of New York and was previously a professor of law at Columbia University. So first, let me just say that we appreciate you joining us here today, and we welcome you. Thank you. We're going to get started. I'm going to remind the audience before we begin that if you'd like to ask questions, I see that people already have, you can type them to us in the Q&A box at the bottom of the screen, and we'll try to get to as many as possible following the discussion. So let's open up. Before we dive into the case, it's important to explain what the ICJ is. Now, each of our guests long ago recommended that their respective countries, the US and Israel, terminate their submission to the general jurisdiction of the ICJ, although the states have agreed to use the ICJ in cases. So can I ask you each to share, starting with Professor Rubinstein, could I ask you each to share your understanding of the court's role and power and to explain your recommendations?
Well, thank you very much, Iana. It's an honor to be with my, I don't say old friend, my friend for many years, for about 40 years, Abe Sofer. We began our friendship in the mid-'80s, and it's continuing, hopefully more and more so in the coming years. I'd like to dedicate and I have great respect for him, great respect. And I also would like to dedicate my remarks to two people in my extended family who lost their life in this conflict. Our relative Hannah Kritzman in Kibbutz Be'eri, who was assassinated by Hamas October 7 at the age of 88 after being in that kibbutz from the age of 17 or so for over 70 years. And the brother-in-law of my daughter, Major Yitzhar Hoffman, who was a war hero, a respected war hero who was killed last week in Gaza. So my remarks are dedicated to their memory. There are two courts in The Hague. One is the International Court of Justice. I put the word justice in some brackets, but International Court of Justice that deals with mainly with dispute between different states. It doesn't have that much work. I think the number of cases they've had since their inception in 1947 is rather meager, but they also come up with advisory opinions requested by the UN Assembly, for instance, or Security Council. The problem with this court is, like with the other court in The Hague, is the political aspect. The justices are appointed or elected by UN bodies, and they come with the baggage of their own countries. I have respect personally for anybody being a scholar, international, or experience, but for Israel, and I knew personally uh, three justices in the past that worked with us on the Egyptian-Israeli Jordanian peace. They personally, I had respect for them. I even befriended them in a certain way, but there's no 1% of a chance that any of them would be objective on Israel in terms of the Arab-Israeli conflict or the Palestinian issues. No chance, and I'm saying that with personal affinity, but with a very strong conviction. And now in this court now, there's a Lebanese justice, there's a Moroccan justice, there are others that you can't expect from them there are others too. And again, one shouldn't kind of generalize, but the court is under a political cloud constantly. The other quote and that is why, by the way, that I recommended in the early 80s as legal advisor to our foreign ministry, basically parallel to what Abe did in the State Department somewhat later, that we should not continue with what in the beginning was accepted, that is the compulsory jurisdiction of that court. The other court in The Hague, and the US also left this or did away with the compulsory jurisdiction. The other court in The Hague is the International Criminal Court, which is aimed at basically at countries that do not have a strong judiciary and a strong legal enforcement framework. And there is an effort all the time, including now, by Palestinians to get us on the list of that code, so to speak. We did not enter the court, nor did the United States in the in the early 2000s. And the reason is again the politicization. Israel does have a strong Supreme Court. It does have a strong enforcement machinery, Attorney General, the state attorneys, and so on. So Israel is not in any way a real candidate to be in the framework of that court as a raising cases against its leaders or its generals or anybody, because we take care of criminal activities, if there are any, by our own people. But so in my speech in the Rome conference back in '98, I made it the point that we are of our apprehension that the court would become politicized, and that is why, as I said, we didn't enter the court, nor did later the United States. And we'll come to why are we there, and I'll finish because Abe is waiting. Why are we there with the genocide? When South Africa, which serves here as a long hand of Hamas and Iran, filed this complaint, our people decided, I wasn't personally involved, but our people decided that since we are still members of the Genocide Convention, which was initiated by a Jewish refugee from Poland in the 40s, Raphael Lemkin, and was accepted by the UN. And we, as the victims of genocide, the Jewish people and the Holocaust, felt the obligation to remain and to be in that members of that convention. We decided now to respond to the court, although there were voices that said we shouldn't have done it, because we have respect for the court, but also we have respect for the Genocide Convention. I'll finish now by saying that there is no, there isn't the slightest legal, real reason why Israel should be accused of genocide in Gaza. The slightest. I speak legally and I speak morally, and I think we'll have the chance to explain more. But this point I want to underline very, very strongly. We are there not because we believe we are part of this case that we have genocide atrocities in Gaza. We do not. We do not. So let me stop here.
Oh, Ilana, so the United States did not approach the ICJ with the attitude that we want to divorce ourselves from it. Far from that, we tried very hard to have a good relationship with the ICJ, and we continue to do that. But we've repeatedly been disappointed by the politicization and the expansive interpretations that they come up with. And so we did terminate the compulsory jurisdiction submission during my tenure. And I worked very hard to get the US to ratify the Genocide Convention. Unlike Israel, which ratified very quickly, the US did not ratify until 1988. During my term as legal advisor, I worked because Ronald Reagan wanted to ratify, as did George Shultz. But when we ratified, we reserved under Article 9 in a manner that said, you could sue us in the ICJ only with our consent. And Israel has not done that. It's something Israel should consider because the several states about 16 states have that reservation. Many more had it. And it's a sound way to avoid suits like South Africa's, which really are a classic example of political harassment. We use the ICJ quite often. Its panels are very effective, where we have say 5 or 3 judges, mainly 5, and the 2 sides will appoint 2 judges each, or choose 2 judges each, and then a chairman will be selected, or chairwoman. And that has worked very well for us, and we continue to use the ICJ on that basis largely. That's our situation.
Thank you both for those remarks. Okay, so let's move to the case. And as I said, we'll try to get through as much as we can before we head to questions. As Justice Rubinstein, I think, more than hinted at, there's a long diplomatic history between Israel and South Africa that's probably relevant to interpreting the case, but which we will skip past so that we can get to the legal questions. So to sum up very quickly, South Africa sued Israel at the ICJ, claiming a violation of the Genocide Convention as regards the Palestinians. It demanded that the court require a ceasefire and a series of other remedies. Israel rejected South Africa's claims, emphasizing steps taken to provide humanitarian assistance and to mitigate civilian harm. In the preliminary relief decision, which was issued on January 26th, the court assumed jurisdiction of the case under the convention, ruled that the low standard of proof of plausibility had been met to continue the case, and mandated certain steps by Israel that we're going to unpack. It did not determine that genocide had been committed, I should say, nor did it call for a ceasefire. Let's first look a little more at the Genocide Convention, and I'll turn back to Justice Rubinstein. Can you explain the implications of the court's reliance on the Genocide Convention for jurisdictional purposes and the sorts of penalties that might be implicated for Israel and its allies if the case turns against us? And what, in your view, was the proper legal framework to assess these issues?
Thank you, Eliana. First, there is a very strong asymmetry in this case. Why? It has turned the facts and the law in a way upside down. Why? Hamas attacked us, and I'm sure that everybody that is now watching this webinar is aware of that. Hamas attacked us on October 7 without any provocation. In fact, just to remind, Israel left lock, stock, and barrel the Gaza Strip in 2005, including scrapping villages that we had there, people who lived there. Hamas turned it, and this is a fact, this is not propaganda or anything of the kind, turned it into a network of tunnels, of ammunition, and it was attacking Israel with rockets constantly. And here on October 7, this massacre of so many people, both in the villages, kibbutzim, moshavim, that is all kinds of villages, and towns in that area like Sderot, and a nature party that took place near one of the kibbutzim. They slaughtered people. This all finds its expression in the 1,200 people or so were killed that day, many of them in their beds, including the relative of ours. In the court decision, with respect to the court, in the court decision, the whole thing is mentioned by one sentence, in the beginning. And the asymmetry is that here is Israel bombing Gaza, and how come that Israel is bombing as if there is somebody innocent sitting on the other side. That's not the case. One more point, Hamas has been using, this is also a fact that is now, nobody now can deny, using mosques, hospitals, schools as a basis for their rockets, for their munitions, and so on. So we did what any country would do. We had to take care of what's going on. Now we had to evacuate all our population in that area, as well as in the north, because of Hezbollah, yet another terrorist organization. The convention, Article 2, says genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such, and then there's a list of the activities that come into this definition. There is no question, and I'm sure that at the end of the day, when the court will come up with its final decision, it will say that there's no intent by Israel to destroy the Palestinians. Israel signed with them the agreements. Israel is working with difficulties with the Palestinian authority, and there is no question, and I don't think there's anybody serious that would think that we have the intent to destroy the national group called Palestinians. What we do in Gaza is to try to eliminate the abilities of Hamas to kill us. And that's what we are doing there. And as far as the humanitarian side, and you asked about the legal framework, yes, there's the humanitarian law, there's the laws of war. The laws of war permit self-defense. It has to be done proportionally. What is the proportionality in this case? The efforts by our military are to reduce as much as possible, and it is difficult, the casualties to Palestinians. But we have to go after Hamas commanders, leaders, soldiers, even if they pose as innocent civilians. And that has been the terrorist strategy all along. Abe was involved in, among many other good things that he did, in making the US not join the second protocol of the Geneva Conventions, because it is a tool for terrorists to get protection to a great extent. So we do abide by the laws of humanitarian international law, and under difficult circumstances, and the population is advised to do A and B in order to save their life, we do allow humanitarian aid by international law, since we are not in that area and we are not conquering the area in terms of a military government or something like that. We do not have the obligation to supply them with water and food. But what we do is, that by that we abide by international humanitarian law. We cooperate with others, like with Egypt, and who do provide food, and we let all the food go in trucks every day throughout this period. As far as so, at the end of the day, the question is, does the genocide convention apply? It does not, because there's no intent. The framework to deal with these issues, as I said, humanitarian law, laws of war. And personally, I think that the orders by the court shouldn't have been given, but as they were given, we are respecting them by submitting this report that they asked for. And I hope that this report will not become a kind of a beginning of more requests by them. And we are also, without regard to the court, but also with respect to the orders, we also supply humanitarian, we help or we cooperate in supplying humanitarian aid. I underline, in my view, all this shouldn't be done in the framework of the Genocide Convention. It does not apply.
Well, you mentioned the intent prong, which is quite important, and I know that this both connects to work that Judge Sofer did in the U.S. on the Genocide Convention, and also it relates to my next question, which was to understand the court's kind of finding, or what it claimed were the findings and reasoning leading to its order. So for that, I'd like to turn to Judge Sofer, and you're welcome to talk a bit about the work that you've done or to sink straight into the case.
Well, there were 6 orders that the court issued, and it's significant to talk about them specifically. They rejected the notion that Israel be enjoined from carrying on the war, which is a highly significant, because this was a unanimous decision, and the court obviously rejected South Africa's claim that Israel was violating the Genocide Convention by doing so. There was no even plausible evidence that Israel is violating the Geneva Convention that would lead the court to issue an injunction. Now, that's very significant, and I think it shows a sense of proportionality and sensibleness in the court's judgment. However, so what the court issued, the first 2 orders were that Israel has to abide by the Genocide Convention, which of course it has agreed to do. And then it says that Israel's forces have to abide by the Genocide Convention, and Israel has to make sure of that. So those are things that Israel has already agreed to do. And the third order is that Israel has to cooperate with measures to prevent and punish direct and public incitement to commit genocide. And that is something that is very controversial, based on no particular analysis of its own. The court concluded that some statements made by Israeli officials might be evidence, some kind of plausible evidence of incitement. And there were statements that talked about hammering the Hamas. Now, not all the statements mention Hamas repeatedly. And one of the statements in particular, the president of Israel said, we must abide by international law. And then he went on to say that there was a lot of enthusiasm among the Gaza population for what was done on October 7th. And that's unquestionably true. They were dancing in the streets, and a lot of people were happy about this horrible stuff that Hamas did. But the court treated it as though this was evidence of incitement, when the president had started his statement by saying Israel had to abide by international law. So the court did not make conclusions of its own regarding any of these statements, and just said, quoted them, and then said, in those statements, in the terrible suffering that the Palestinian people are encountering, and the manner in which Israel has conducted the war, these three big batches of evidence, there's plausible proof of genocide that would justify these kind of measures. And the fourth measure was that Israel would cooperate in assistance to the Gazans. And of course, Israel said that it is cooperating and is cooperating, and has agreed to cooperate. And here's another instruction that was virtually unanimous because it was something that Israel had agreed that it must do and was doing. Now, there were two other instructions, two that are very, very important, and people haven't given enough attention to them. One is that Israel take effective measures to preserve evidence. Now, the reason I'm focused on that is because there's absolutely no evidence mentioned that Israel has done anything to destroy any evidence of its conduct in Gaza. Every order has been presented that's relevant. Israel is ready to present all its instructions to its forces, and yet the court accepted that order as though there were some need to tell Israel not to destroy evidence. And the final order that is greatly concerning is the order that Israel respond in 1 month, explaining what it had done to satisfy the court's order. Now, the court does have the power to do that. And what it was asked to do is quite extraordinary. South Africa asked Israel, asked the court to order Israel to provide a weekly report on all its conduct related to the war. Now, if the court, in getting this response from Israel, continues along that line, it'll end up being a monitor of Israel's conduct of the war. And obviously, a court does have the power to monitor illegal conduct. But you've got to remember here, the court here has made absolutely no finding of illegal conduct. None. All it has said, and it has been very general in its statement, is that there's plausibility to certain arguments made by South Africa. And here it will be taking a monitoring, potentially, a monitoring role over Israel's conduct of the war. Now, if this case goes to that point, I imagine that Israel will have to respond in some perhaps less respectful way than certainly Israel would like to respond, and that I would like to see Israel respond. But those are the rulings of the court and my reactions to them.
And let me just, Liana, with your permission, his permission, say that I mentioned our president. Our president has been advocating, President Herzog has been all along advocating abiding by international law, and the notion of quoting him because he made a point to say that there are many citizens in Gaza that support Hamas, many inhabitants of Gaza, which is unfortunately true, including UNRWA, the International Agency of Aid for Refugees, which has been there, and its own staff has been involved, many of them, which is now obvious, and many countries now say withdraw their support to UNRWA, and UNRWA is quoted as a source in the court decision to and also the human rights bodies of the UN, which are always, even if you talk in the calmest, most calm way, biased against Israel. Sometimes you have a Syrian representative sitting there and telling Israel how immoral it was Syria that killed 500,000 of its inhabitants, its own citizens 10 years ago. So as Abe said, the plausibility or the notion of evidence it doesn't exist there. So the feeling is that let me tell you something. When I was Attorney General, I used to sit on all cabinet meetings, and we at the time had military activities in Lebanon and so on. And I was constantly in every government meeting, and so was the Judge Advocate General to the Army people, reminding, coming up with instructions, coming up with very strong instructions to abide by humanitarian law. And that's what President Herzog also said, we abide by that. I think that Abe, with his analysis, showed how in every point this is flawed in terms of our being included in that genocide convention as perpetrators of genocide. No way.
So I want to do two things before we turn to audience questions. Time is flying. And I think that people are quite curious to know, in light of really the wealth of experience that you've brought to this discussion, how is Israel to handle this case in the short term and in the longer term? The feeling on the ground is that there is a long war to wage. There may in fact be another front opening up at some point in the north. And they're trying to understand the implications of this ruling. I'll throw in here, since I see that audience members are starting to ask, there's also been a change of president of the court. The president was previously American, and this week it switched to Lebanese, somewhat different affinity toward Israel at the national level. So how does Israel handle what, based on this discussion, seems to be more political than legal decision? And then once we talk about that, I'd like to talk about what lessons Israel and America, which albeit differently positioned, what lessons they should be drawing from this and what measures they should take to protect themselves against what may effectively be international lawfare. So it's possible that Justice Rubinstein has the most insight into what Israelis are thinking now in terms of their next steps. We'll start there, and then we'll move to Judge Sofer.
Well, thank you, Leanna. And indeed, as you said, the fight is much more on the public level than on the legal level, although the legal level has its importance. I should have mentioned also that Israel appointed to the proceedings former Chief Justice Aaron Barak. He's a Holocaust survivor at the age of 7. His mother carried him from Kaunas, from Kovno in Lithuania, out of the ghetto to farmers who were ready to give them shelter for a while. And he always says that our lesson from the Holocaust is twofold, 2 lessons. One, the need for a Jewish state. The gates will be always open for Jews in distress, and are always Jews in distress in any given period. And the second is human rights, to abide by human rights. And the Supreme Court, of which I'm proud of having been a member for many years, is the guardian of human rights in Israel. And unlike any Supreme Court, it takes petitions right to that court without going through the echelon of courts on government decisions, many of them on civil rights and human rights. You go direct to the Supreme Court, and I sat personally on many petitions that included Gaza, included the West Bank or the Judea and Samaria area, and the petitions were aimed at human rights issues, and we solved them, including, for instance, about more than 10 years ago, there was an operation in Gaza, and on real time, online, you can even say, we sat on petitions, on supplies, on other matters, humanitarian matters, throughout that operation. So that's how we function generally. Now, to look at the future, I assume that our people will submit that report, hoping that this is a one-time report. I know that there are discussions in the Attorney General's office to see what we're going to do with Hamas criminals that we have detained throughout our operation in Gaza. And we will continue chasing not Gazans, not Palestinians, Hamas leaders. That's what we are chasing, and that's what we are after, even if they shelter themselves under within the general Palestinian population and being sheltered by them. I remember well when I was Attorney General that one day there was a meeting in my office, and the army generals who were there told me, look, yesterday we could do away with the whole Hamas leadership. We didn't do it because the meeting was in a building where there were many civilians let's say, the 4th floor of an 8th floor building, and we refrained from doing it. We are also concerned, by the way, of the pending advisory opinion in that court, and also the efforts to implicate us in the other court, the ICC. But I don't think we have the time to go into each of those elements, which are also it's so sad, but it's ironic. There's one villain in the world, Israel, one villain. Everybody legally speaking, diplomatically speaking, I have no doubt that had the US been attacked by terrorists from Mexico in its southern border, we'll find the US acting very, very strongly against, not in any way different from what we are doing. And the same with other countries, with Britain, we have enough examples, Britain with the IRA and so on. This is something which we don't like to do, but we have to do.
Thank you. Judge Sofer, if you could comment on what you think Israel's next steps should be in light of where you seem to think, or where you think this is going, that would be great. And then also we can move directly from there to the question of what's America supposed to interpret and do going forward?
Well, let me mention that Chief Judge Salam, the new Chief Judge of the ICJ, is a Lebanese national, but he's a highly professional diplomat and international law scholar. So I don't think it's justified to focus on him in any negative way. He is part of the court. He's been a part of the court for years, and you have to expect him to behave in the way that the other judges have behaved on that court. But Chief Judge Salam has done many things in his life, including representing Lebanon in the UN. And he's a highly respected person and a scholar who's actually studied in the United States. So I don't think the issue is personal. The issue is, what is the court doing and how does it fit in with our understanding of how courts should behave? And to give you a sense of this, I thought about, well, could an American court or an Israeli court or a British court or a South African court, any national court, issue the kind of ruling that this court has issued on the basis of plausibility of this, or plausibility of that, the plausibility that there's a right, plausibility that there's evidence, no finding whatsoever, even on the issue of any of the statements being incitement. It just, in terms of the evidence of genocide, they threw all these three categories of evidence into one pocket and said, it is plausible that somewhere in those three categories of evidence, there's evidence of genocide. Now, in the United States, for example, a federal state court can issue preliminary relief on the basis of likely success on the merits. This is a prerequisite to getting preliminary relief in a case, likely success on the merits, not plausibility. Secondly, likely irreparable harm without preliminary relief. Third, that the balance of the equities between the parties supports an injunction. And fourth, that an injunction would be in the public interest. Now, these four requirements that are commonly applied in the United States and many other states make it necessary for a court, before it would issue a preliminary measure of the kind that this court has issued, to make a large number of very critically important findings, whereas this issue, this court has gone virtually to the point of just kicking the can down the road and enabling the court on February 26th, when Israel files its 30-day report, to actually continue the process of imposing provisional measures and monitoring a war on the basis of nothing, essentially on the basis of plausible arguments. I consider that an extreme form of judicial power that makes no sense, and that any country in its right mind has to take into account in determining the extent to which it's going to submit itself to the jurisdiction of the court in those circumstances. So I think that, without, if this is the way the court works, and it doesn't have to make findings in order to impose the kind of conclusions that it has imposed and rulings that it has done, and the court continues to have jurisdiction over this matter, and Israel faces, unless it reserves against the Genocide Convention under Article 9, other possible cases under the Genocide Convention by other states who are representing Hamas. I think that it makes sense for Israel to take these factors into account and make some decisions that are basically sound in terms of its national interests.
Sorry.
Eliana, just to add that personally, I think that we shouldn't abandon the legal arena and look at and show that this war has its complexity. We have not the. There were some statements by Israeli politicians, not those quoted in the decision of the court, that shouldn't have been said. But you ought to understand the rage that people felt when they saw that this lady, Mrs. Silver, for instance, from one of the kibbutzim, Be'eri, who was driving Palestinians to Israeli hospitals as a volunteer for many years. She was killed there that day. And then the fact that the Hamas is using the civilian infrastructure to use the people as a human shield for them, it shows the complexity of what's going on there. So we ought to, on one hand side, to continue being humane as far as we can, but on the other hand, to try to demonstrate in the international arena everywhere our legal and factual situation, and including, by the way, and it was hinted by Abe, coming up with initiating proceedings in the court against states that help Hamas to commit genocide-like activities, Nazi-like activities that were those who were perpetrated. We don't like international courts, but once there is such a discussion, it would be right to use the opportunity and attack legally, as two Israeli scholars recently pointed, Pnina Sharvit Baruch and Tami Kanner. It is something which we should consider also. Suing.
I would just I'd say this in terms of supporting what Elyakim said to some extent, at least. The court is said in its opinion that Hamas should immediately and unconditionally release all the hostages it's holding. I consider that a highly important fact, that the court went out of its way to say that. Hamas was not before the court. The court could not order Hamas directly to do that. But that fact that the court said it is absent in many discussions about this issue of the Genocide Convention. People act, as Eli said, people act as though this whole case is about what Israel has done. At least the court did say that. Now, how important that is reflected in the fact that probably most people in the world don't realize that the court ordered Hamas, not ordered, but said that Hamas should immediately and unconditionally release the hostages, because it's buried in this long dissertation based on plausible this or plausible that, and instructions ordered to the Israeli government. It's really an amazing contrast of what's really going on in the world and what's going on in the courts.
Well, I want to.
I'm glad, Elena. I'm glad that I mentioned, which I should have done before they kidnap people. It is mentioned at the end of the decision of the court. This is super tragic that 136 people are held there, babies, old people. Well, why? Why are they there? What did they do? Why kidnap old ladies and old men from Gaza, from the kibbutzim, and put them in cellars and drag them all around, and including, as I said, babies. This is the violation of international law. Where is it? Well, the court said it's buried in the whole avalanche of decisions. Abe is so right on that, and it's so important to mention that.
I wanna take the next few minutes, and we're already at an hour, so we only have a little time left, and I want to make sure that some of the audience questions are addressed. And I want to maybe focus on what could be a tension in statements that you've both made. I think a lot of people are wondering, well, how does Israel and potentially the United States, because I think very often Israel is kind of like the canary in the coal mine in these things, but how does Israel effectively use lawfare to its advantage, right? On the one hand, and use these international courts. So you had mentioned the potential to bring suits. I'd love to know what that looks like. Um, but on the other hand, there's a sensibility in what you're both mentioning, which suggests that there's a lot of politics at play, and maybe that it seems less likely that Israel will emerge from cases against it unscathed. So, can you talk a bit more about ways we defend ourselves from that and ways that we potentially try to use these institutions to our advantage?
Well, would you like to start, Abe, or should I?
I could just quickly mention that there are groups in Israel and the U.S. that have brought suits against PLO for killing Americans and killing Israelis, and they've been very successful. They've gotten a lot of damage orders, and they can it makes a difference. And there are now laws in both countries, especially in the U.S., that permit private suits against terrorist organizations that do the kind of thing that Hamas did here. And those are important developments that should be utilized. But ultimately, I mean, in my opinion, based on my experience in the government and dealing with terrorism, which if you don't use force, it's like allowing your people to be killed and then suing about it. I mean, you have to be able to what Secretary Shultz used to call an active defense. You have to be first focused on preventing your nationals from being killed and innocent people from being killed. And that's an imperative part. And then, of course, using law in the right way is very sound. Go ahead, Ellie. You can add to that.
Well, I think I agree with what Abe said, and I've always been supportive of those cases brought against PLO people and terrorists in certain courts, mainly in the United States. We should be more active in the international arena. We could have countries like the United States, like Britain, like Germany, others, to support our legal approach. And the idea should be that don't focus on us only. We are trying our best to abide by international law. Look around us and look at the Hamas people and the Hezbollah people at Iran. Look at their activities. Where are they with international law? I think that it could have an effect. I don't think we can solve the problems with that. Let me be frank. There's anti-Semitism. It's not only anti-Israeli bias in various fora. It's also anti-Semitism And it's not something pleasant to talk about anti-Semitism. I remember when I was cabinet secretary in the 80s, I suggested we start monitoring anti-Semitism. A major Israeli figure who was in the government told me, why should we deal with that? Government should deal with the present and the future. Anti-Semitism is the past. Why deal with it? That was said in the late 80s. Look where we are now. But even if you know you cannot uproot it, if you know you cannot uproot the bias against Israel, you should do two things. One is fight, struggle, not don't lose hope, don't despair. And the other is behave properly, continue monitoring human rights in terms of instructing the army. Our army has a very active judge advocate general's corps that is accompanying the divisions, the brigades, the regiments, to make sure, the battalions, to make sure that they abide by law. We should continue with that. And I think this is a must, and this is something which can be done and should be done.
Okay, we're going to give this, I think, 5 more minutes. Let me turn to another question that's come up from the audience, and I'll make it a twofer. One is the chances of suit being filed against Israel in the ICC, which I imagine are quite high over the next couple of years. What the implications of that are, and again, what the response should be if it's in any way different from what we're discussing already. And then again, what sticks with me from the messages of what you seem to be saying are that it almost sounds like, we're going in with a hand tied behind our back, always, to these fora. And I think the question becomes, well, what happens in the worst case scenario if you're right and these rulings go against us? What do we do at that point? So ICC, and I think this last question as well. Perhaps we'll start with Justice Rubinstein and conclude with Judge Sofer.
Well, thank you, Liana. And by the way, I'm very impressed by the questions that we have with the audience. Personally, I would sit here for hours and try to allude to any question. Many are very good questions, and I apologize to all the participants that will not be addressed personally. To your question, as far as the ICC, it is worrisome. For years, there were complaints by Palestinians or their supporters to try to drag us to ICC. We decided back in 2002 not to enter the ICC by the way the United States decided. And we were concerned by the politicization that can come up with an organization which is elected politically, even though you can have respect, as I said in the beginning, to this to each judge personally. The ICC complains. There's a prosecutor there who is conducting some kind of a procedure process there. We have two legal arguments. One I already mentioned, the fact that we have a strong judiciary and a strong enforcement machinery, and this is not the case with what the ICC is supposed to deal with. They are supposed to deal with countries who do not have that. The second point is jurisdiction. We don't think they have jurisdiction on us, and I won't go into the. I hope worse doesn't come to worse. But I think that we should be prepared. We should make our point to them, and we should try to convince them to be as professional and legal as they should be, and I hope that the current prosecutor, I don't know him personally, I read his bio, will be responsible and will really look at it from this point of view. And that's as far as the ICC. What was the other question, Eliana?
I think this was maybe a merger of both, which one was about what we do with the ICC, and second is, given the kind of recurring mentions that have been made in the course of this conversation, which on the one hand want to respect and uphold the legitimacy and credibility of international legal institutions, but on the other hand recognize certain political realities. So, for instance,
Let me conclude with a story, because we've already touched on all these things. Back in 2002, maybe, a Palestinian group filed a complaint in a Belgian court of law using what's known as the universal jurisdiction. That is, that countries take the liberty to judge other countries in terms of their complaints filed to them. So Belgium got this complaint against General or Prime Minister Sharon, whom Abe knew, who was our Prime Minister and who was the Defense Minister 20 years earlier when a massacre occurred by Christians against Muslims, Palestinians, in Lebanon in the camps of Sabra and Shatila. 20 years later, and what Israel did at the time was to establish a very highly respected inquiry committee who came up with conclusions and made Sharon resign from his Minister of Defense position and so on. And many generals had to leave their posts. We investigated thoroughly. Barak was on the panel. Lebanon did nothing against the Christian perpetrators. And then 20 years later, here we are in Belgium, having to, and we started talking to the Belgian authorities, telling them, what are you pushing yourself into that? How was it solved? Simple. Somebody did one step too much, filed a complaint against America, against Powell, who was the commander of the U.S. Joint Chief of Staff and in the Iraq war at the time, filed a complaint against Powell. And as far as I know, the U.S. told Belgium that if this case is not finished, finalized, put away in as soon as possible, we're going to take NATO out of Brussels, which is a major source of income to Brussels. Sure enough, in a couple of weeks, there was a law enacted in the parliament that curbed this universal jurisdiction, and Powell was off the hook, and Israel was off the hook, the Belgian hook. So here comes politics into law, and I brought this example to show how complex and how difficult it is to deal with these things internationally, but we don't despair. We shall overcome even that. Thank you. God willing.
Thank you. Judge Sofer, I'm going to give you
I think it's a very
remarks.
good story, and it teaches a good lesson. One has to be firm in the face of absurd and politically driven international legal efforts. On the other hand, we have a duty to be honest, to abide by law, And we do make mistakes, and we deserve to be punished for the things we do wrong. And we deserve to punish our soldiers who go the wrong way, and we all do. Both Israel and the U.S. Tries its soldiers who violate the laws of war. So it's tough. It's hard to manage that whole thing, but you can't be a fool as a state. You have to look at the reality of the forum that you're being asked to explain yourself within. And the ICJ as a whole unit is a place where you cannot count on the kind of justice that I think both the United States and Israel and most states in the world want and need. So you have to be realistic, and you have to be honest, and you use the ICJ in a sound way in many cases, border disputes, commercial disputes, lots of issues. I took to the ICJ personally as legal advisor in the State Department. And I don't like the expression fighting with one hand tied behind your back. Judge Barak is the one who coined that phrase, that Israel has agreed to fight with one hand tied behind its back. I don't think it's really accurate. Israel fights just like any other state fights with both hands. But with the order to every fighter that it abide by the law. And that's something we have to stand by. And in opposing the ICJ's jurisdiction without our consent, the United States in the genocide case isn't saying we will never adjudicate a genocide case. We will, and we would if that were appropriate. But we would do it under the terms and conditions that we'd be able to impose because we had reserved under Article 9. And that's the realistic way to go about things, not to condemn the law, not to avoid the legal principles at issue, but to avoid being made a fool of and taken advantage of in a court that really isn't balanced. Thank you.
Thank you. We have come, unfortunately, to the end of our time. I want to thank both of our guests again, especially Judge Sofer, who's been a guide in putting this event together as well. And of course, thank you to Justice Rubinstein. I will say also that our hearts are with you at this time of personal loss for you and for so many of our fellow.
Let's pray together for the kidnapped people, for the for everybody who suffers in this very complex situation. And I hope this prayer be answered as soon as possible.
Amen. We will be sending out a recording of this event next week. I encourage people to stay tuned for that and for additional programs on the challenges and opportunities facing us in the context of this war. Good night from Jerusalem.
Thank you very much.